What is probate? Hi, I'm attorney Paul Delary. In this video, I'll provide a comprehensive overview on the key aspects of the probate process. Stick around until the end because at the end of the video, you'll hear a real-life story involving 3 common mistakes that a personal representative actually made when trying to do a probate on his own, and it almost cost him his inheritance. You'll find out what not to do as personal representative, so if you happen to be in that role, you can properly handle the role and avoid disputes down the road if you ever need to handle the probate yourself. So let's dive in. First, what exactly is probate? Probate is a legal process in which the local court system verifies that a deceased person's will is authentic, assuming there was a will. It also authorizes someone called the executor or personal representative to manage and distribute estate assets to heirs and beneficiaries. Here in Arizona, we refer to the person in charge of a deceased person's estate as a personal representative. Other states might refer to that person as executor or administrator. The probate court oversees the probate process to ensure the estate gets settled properly according to state law. Now, probate procedures can vary considerably between different states. Each state has specialized probate courts, though they may use different names. Here in Arizona, it's simply called the probate court. The timeframes, requirements, and costs involved in probate depend on the state where it's filed. Arizona is fairly efficient, with the typical uncontested probate getting wrapped up within about a year. In comparison, the same probate in California or New York would take much longer. Arizona law requires that legal fees and costs be reasonable under the circumstances. Compare that to California, for example, where probate lawyers charge a percentage of the value of the estate, regardless of how complicated the situation was. How you start the probate process depends on whether there was a will. If the deceased person left a will, then someone needs to file the will, with the local probate court in the county where the deceased person was domiciled or owned property. If there wasn't a will, then someone needs to file a document with the court saying there wasn't a will. At the same time, the person filing asks the court to appoint a personal representative. After filing the initial documents with the probate court, whoever is filing for probate needs to provide legal notice to all heirs and beneficiaries, giving them a chance to contest the will's validity if they wish, and/or to contest the appointment of a personal representative. Specific notice requirements vary by state law. If someone dies without a legally valid will, it's called dying intestate. In that case, the personal representative or executor distributes assets according to the state law, the state's intestacy laws. In other words, without a will, the heirs get the estate. Now, generally speaking, let's kind of run down how this goes. Generally speaking, if the deceased person was married and has children who are also the children of the surviving spouse, then the surviving spouse gets everything. And I should say this is under Arizona law. Arizona is a community property state. Other states do things slightly differently. But anyway, this gives you a flavor of what it means by heirs, okay? So in that case, the surviving spouse gets everything. If it was a second marriage, the spouse gets half and the children get half. If the deceased person wasn't married, then wasn't married, then the descendants get everything. If the deceased person wasn't married and had no children, no descendants, then everything goes up to the parents. And if the parents don't survive, then it goes to the descendants of the parents, and so on. Basically, that's a simple explanation of how it works. And if it turns out that there were no heirs as defined by state law, then the state gets everything. So in this case, Arizona would get everything. During probate, the court typically accepts the will and formally appoints the personal representative requested in the will. The court gives this personal representative authority to gather and manage estate assets during the probate process. If the deceased named a guardian for minor children in the will, the probate court can also approve this appointment. This specifies who will take care of any children under 18 years old. Throughout probate, the personal representative must provide status updates to the court regarding asset inventories, as well as transactions made. This oversight protects inheritors' interests and ensures debts and taxes get paid. Under some circumstances, the court must approve selling valuable assets and property distributions. Now, many people have misconceptions about probate. They fear that court procedures make settling an estate overly lengthy, complicated, bureaucratic, and costly. While the probate process has some downsides, most estates can move through it relatively simply within 6 to 12 months. An experienced probate lawyer can help personal representatives navigate any complexities efficiently. There are certainly costs involved with probate, including court filing fees, paperwork processing, necessary legal notices, and attorney's fees if you hire one, or if one is hired. Costs vary greatly by state and estate size. Overall, probate costs usually range from 3% to 7% of the estate's total value, significantly lower than many people expect. As mentioned, the length of probate can range from 6 months up to a year to 2 years or longer for large or contentious estates. Some of the delays relate to waiting on tax documents, creditor claim periods, or property sales. But again, a probate lawyer can help move the process along smoothly and minimize delays. Certain estate assets can totally bypass probate, like assets with listed beneficiary designations or those structured as living trusts. Joint bank accounts and real property held jointly can also avoid probate. Now, let me tell you a story. When a client of our law firm recently lost his grandmother, our client's uncle, Jack, decided to handle the probate process himself without an attorney to save on legal fees. However, he soon made some of the most common mistakes personal representatives run into. First, Jack failed to maintain clear financial records on the estate, making it unclear what debts were paid and what assets were sold. He also neglected to collect his mother's mail. This is number 2. He neglected to collect the mail, and he missed important tax notices as a result. Additionally, Jack did not provide timely updates to the other heirs on the status. Now, these oversights frustrated Jack's brother, who was entitled to 1/4 of the inheritance. The brother filed a petition with the probate court to demand a formal accounting and to remove Jack as personal representative. At this point, the family contacted our law firm, Probate Made Simple. We helped Jack correct the accounting issues and tax filing oversights. We also assisted Jack with communicating complete status updates to all the heirs to rebuild trust. The judge allowed Jack to remain personal representative, but required him to provide regular reports under our supervision. Within 9 more months, our firm guided the successful sale of the estate home and distribution of assets. This situation highlighted that without experienced legal guidance from the start, personal representatives often run into complications. Having probate made simple involved early on prevents problems and ensures smooth sailing through the probate court. What does a probate attorney do? He or she assists with tasks like deciphering complex wills, communicating with beneficiaries, appraising assets, navigating court procedures, and ensuring adherence to state laws. They become invaluable if disputes arise over the estate. So in summary, probate is a court-led legal process occurring after someone dies to distribute their estate assets according to the will or state law. Hiring an experienced probate lawyer early on helps ensure the process goes smoothly. I hope this overview has helped explain the probate procedure, and let me know if you have any other questions about probate.